everybody. My name is Dean Rocco. I'm an attorney out of California, and I work with a law firm called Wilson Elser. In addition to be a partner with Wilson Elser, I am a chair of our cannabis and labor and employment practice groups. All of that gives me a hopefully unique perspective to not only give you some perspective on where legalization stands in the U.S., but also how it impacts employers throughout the country. So first, let's talk about where things stand in terms of legalization here in the U.S. If we go back to 1996, that's when things really started to expand from criminalization when California passed the Compassionate Use Act. And that, for the first time, allowed patients in the state of California to have access to cannabis for medicinal purposes. And for a number of years, you saw a movement, particularly on the West Coast, of additional states coming on board, adding medicinal programs to their legislative tracks. And for a number of years, that's really the only access to cannabis that there was. In 2012, things changed quite a bit when the state of Colorado announced for the first time a program to provide its citizens access to recreational cannabis, meaning persons over a particular age would be able to go to a dispensary, purchase products without having a medicinal purpose for them and using them recreationally. And that really marked a sea change here in the U.S. Currently, we have approximately 12 states in the District of Columbia with access to recreational cannabis, and more than 30 with cannabis available for medicinal reasons. And each state is a little bit different, and oftentimes when I'm asked questions about how issues should be handled, I'll come back to this point, which is depending on how your state handles cannabis, the general advice or concepts that we might talk about today might need to be tailored a little bit. So in some states, I'll use California for example, it's an older state in terms of legalization. The market is fairly robust. There's a lot of patients that can use for medicinal purposes in addition to recreational use. And the legal use is a little bit more prevalent than a state, for example, like Ohio, where I'm sitting today, or just to the north in Illinois, where those programs are just being announced. The access to medicinal cannabis is restricted. There's far fewer conditions that it can be prescribed for, and far fewer patients that are actually going out and using it. So as a result, you can have fewer patients and fewer employees that are going to be running into these sort of issues. That's what's happening at a state level. You've got medicinal and recreational use, but at a federal level, cannabis continues to be illegal. The Controlled Substances Act still leaves cannabis as a Schedule I drug alongside some pretty serious stuff, and therefore it's illegal under federal law. And that has some important implications, as we're going to talk about in a little bit when we get to the employment context. There's some softening, though, in terms of enforcement, as you can imagine, or the question might be in your head, well, how can marijuana be illegal at a federal level, yet people are growing it, manufacturing it, transporting it, and consuming it in all these various states? Well, the federal government, the Department of Justice, has taken a hands-off approach to enforcing the Controlled Substances Act in those states where there are legislative programs in place to allow for legalized commercial cannabis. And provided that those actors in those states are not doing some pretty nefarious things, they will not get involved, and they've allowed states to proceed with those programs. And the same is true when you talk about banking. The U.S. Department of Treasury has announced similar guidelines, and they've taken a hands-off approach and allowed banks to bank cannabis money, provided that people are acting within certain guidelines. So at a federal level, it's still illegal. But there's a softening or a hands-off approach from an enforcement standpoint. And on the state side, there may or may not be some form of legalized cannabis. The other sort of cousin to mention here is hemp. Many of you may have heard that hemp is legal By and large, that is true. Under the 2018 Farm Bill, hemp was taken outside the definition of marijuana. And so farmers across the country now, under programs that will be announced at various different state levels, will be able to grow hemp. And apropos to today's discussion, you're going to have more and more employees having access to CBD and hemp-derived nutraceutical or medicinal-like products, and those may impact what happens from a testing standpoint or engaging with employees about their use of cannabis or hemp-derived products. Some things to note on an international level. Internationally, hemp is still, or cannabis is still listed in the single convention as a schedule drug, along with a lot of the other drugs that you see in the Schedule I drug here in the United States. The World Health Organization and the physicians that support that organization, just like doctors here in the U.S. are struggling with how to classify marijuana and hemp, are doing the same at an international level. Certainly to the extent that they might loosen those standards or reschedule or deschedule marijuana at an international level, that might change the way the U.S. feels about controlled substances and the Controlled Substances Act, because the single convention at an international level is what led us to have our Controlled Substances Act back in the 70s. So that's sort of the landscape. As you can imagine, there's a lot more people that are at least telling pollsters that they're in favor of cannabis legalization. A higher number are in favor of cannabis for medicinal use than for recreational uses. And many more people are telling pollsters, again, you can trust the numbers for what they are, but they're telling pollsters that they're using cannabis more than they ever have. And these numbers are really getting north of 50% into the 60s when you're talking about attitudes towards legalization and use, which means for everybody that's in this webinar or who's watching this video, the reality is you are going to have more and more of your employees and your staff that are going to be exposed to cannabis, that are going to be using cannabis, and you're going to have some discussions with them about how cannabis would be used in the workplace. So let's talk about what that really means. The first place where cannabis at work, we can skip ahead a little bit. Yeah, we're going to show you some slides here just so you can see. This is cannabis legalization in the U.S. There's California in 1996. If we click ahead a slide, you'll see where things stood in 2012, when Colorado and Washington legalized for recreational uses. If we skip ahead one more slide, that's where we stand right now. So all the states in red, those are the 30 plus with medicinal, and the ones in blue, including the District of Columbia, are those with recreational cannabis available. We can go ahead and skip ahead. Here's the international map. We can continue to skip ahead a couple more. We've talked about hemp legalization. Keep going ahead there. Let's start here. So when we're talking about cannabis in the workplace, or weed at work as I like to describe it, the first stage that you have to be asking about your own policies and your procedures is whether or not you can screen applicants. Now you might be saying, well, Dean, it's illegal under federal law. We don't have to break federal law, and we're going to have a zero tolerance policy, and we're going to screen everybody out. And if anybody tests positive for marijuana, we're not going to hire them. And in many states, you can still take that approach. However, in an increasing number of states, particularly those that are newer to the marijuana party, so to speak, when they're rolling out legislative enactments, they're thinking about issues about employees' rights to use cannabis and their ability to be screened out from employment as a result of it. And an increasing number of them are adding statutes that says thou shalt not test for marijuana, or thou shalt not screen out an individual from employment for off-duty use. And so for those folks in a state like Nevada, or folks that are in around New York City, there are laws that are going to restrict your ability to screen cannabis use. And so you're going to have to take those into consideration, whether you've got one facility there or maybe you're in multiple states, and you have to think about adopting some policies that might change from state to state or even municipality to municipality. Let's go ahead and take a look at the next slide. To accommodate or not. Now, this is a place that I've been telling folks for a number of years that this debate was going to move. Now, if you can think about things, again, you might be saying, well, we think marijuana is illegal, or I think marijuana is illegal under federal law. And I think it's a controlled substance, and therefore I don't want my employees using it. But when you think about people that have disabilities at work and the types of treatments that they might need, oftentimes they are prescribed drugs that are on the controlled substances list. They may not be Schedule 1, they may be Schedule 2 or Schedule 3, but whether you knew it or not, now you will know that those employees, as a condition for them getting treatment for their disabilities, are oftentimes taking controlled substances. So the question naturally arises, well, if somebody can take an opioid for pain, then should they be able to, or why couldn't they then consume medical marijuana for those purposes? And an increasing number of states, as they're announcing their legislation, have said, we think that that's something that should be permitted, or that's a conversation that an employer should have. And so as a first step, you need to look at the regulations in your state to see whether or not they obligate you as an employer to engage in the interactive process with the employees about whether or not that sort of cannabis use is something that you can reasonably accommodate. In other states where there were not laws on the books, and particularly this is happening in the Northeast, so if you find yourself there, listen up. The courts there have had to grapple with this, and they've looked at the state disability discrimination cases and the laws, and they've said, well, if an individual has a disability and marijuana treatment is something that they and their doctors feel they need, do we as a court want to impose an obligation on employers under that framework to accommodate employees? And a number of states have said that they may have to, or they must. And oftentimes in those cases, the employer said, well, we have the Controlled Substances Act. We have federal law that says this is federally illegal. We have the Americans with Disabilities Act that certainly wouldn't require an employer to accommodate marijuana use because it's illegal under federal law. So how can you really reconcile all of this? And courts have said, well, we've looked at the Americans with Disabilities Act, and it doesn't say anything about drug use and cannabis use, and preemptively saying states can't do something different. And so they've largely said the Controlled Substances Act, which doesn't really talk about employment rights, and the Americans with Disabilities Act are somewhat silent and really not controlling on this, so we'll make it a states' rights issue. And in those cases, we've had a number of states, particularly as I mentioned in the Northeast, that have said, we're going to require employers to have this conversation. So if somebody walks into your facility and says, hey, just letting you know I'm using marijuana because of epilepsy, or I'm going through chemotherapy, I'm going to be taking cannabis for pain or appetite reasons, before you simply jump into action and say no, you really want to talk with your counsel to see what your obligations at that point would be. So let's take a look at another slide. Responding to addiction and abuse. Oftentimes an individual will not necessarily come forward when they want to take cannabis or use cannabis for medicinal reasons, but they'll come forward after they've become addicted to or having trouble controlling their use of a controlled substance like cannabis. Understand that there are some long-standing rules that are out there that obligate an employer to not simply drop an axe and terminate somebody like that, but to determine whether or not they have to accommodate the individual or provide them some sort of leave. The Family Medical Leave Act, ironically enough, which is a federal law, which partners up with the Controlled Substances Act, says substance abuse is a serious health condition for which an individual would be entitled to up to 3 months of leave or 12 weeks of leave under FMLA to get treatment. So while the underlying use of the drug isn't permitted under federal law, treatment under the Family Medical Leave Act would be protected. And similarly, the Americans with Disabilities Act sees drug addiction as a disability and tells employers, if you have an individual that comes forward with an addiction issue, you have to engage in the interactive process to see if there's an accommodation that can be made. And again, time off to go get treatment is something that would need to be accommodated. So if there's two sort of issues here on the disability front. One is, does the individual get treatment with the cannabis? Maybe. The other issue is if the person comes forward and says, I'm addicted to cannabis, I need some treatment or some time off around that disability. Absolutely, on that end of things, you're going to have to act under federal and oftentimes under state law. There's a lot of sister states laws that will track what the ADA and the FMLA say on drug abuse. International business. Some of you may have individuals going across borders to Canada, for example. There's national legalization there. Individuals may be traveling internationally for work and going to countries where cannabis is legal. Oftentimes we're asked, well, does that individual, if they use cannabis while they're on a business trip, are they afforded protections because where they were it was legal? The short answer is, typically speaking, when an individual is working in a state, in a municipality where cannabis use is not protected, when they go out somewhere else and use cannabis, the employment laws where they work are what's going to govern. But this is an emerging area and one that has not really been tested yet. And so again, if you have this issue come up, I would definitely ask you to speak with your employment counsel to make sure the law hasn't changed. Even if they're not traveling to Canada or internationally, it's certainly not uncommon with cannabis tourism for people to be traveling to a state like California or Colorado or Washington, or even if you're in Ohio here and you drive up to Chicago for business, individuals are going to be able to get access to recreational cannabis. And so these issues are going to blossom and develop in coming years. One of the other issues, we'll hold right there for a minute, but one of the other issues that I understand you all are dealing with quite a bit is palliative care and nursing home care. And I understand that a number of your staff are going to be in facilities where individuals are receiving that sort of care or might even be dealing with terminally ill patients. And our health practice group is increasingly being called in to answer questions about whether physicians can prescribe cannabis to those sort of patients, whether they can just simply permit it and say, you can have it if you want, we're not going to prescribe it. But if there are patients that are in those facilities that are using cannabis for medicinal reasons, your staff are going to be exposed to it. And so it does lead to a question, for example, that was on that last slide of, what if an employee takes a stance and says, well, I don't want to be around cannabis, or I'm not going to work around cannabis. Or you as an employer says, we're not going to permit this for patients that are under our care. What I would tell you is the law here is quickly developing. In many instances, the patient in that nursing facility is not going to have a right per se to the use in that facility. They can choose another facility. So if you wanted to box cannabis use out entirely, that is something that you might be able to do. But there's no law and there's no cases that I've seen where an employee takes a stance that's contrary to the employer's position on permitting cannabis in the workplace and then quitting, for example, and claiming constructive termination. If that issue were to arise for you, I would say speak with your local counsel, your employment law counsel, when that issue arises, to see what the law in your state says, if anything. You may just be the canary in the coal mine on that sort of situation and have to balance some of the risks given what the law looks like in your state and make the best decision that you can under those circumstances. The last thing that I wanted to talk about before we get to this next slide is right to use states. So in a growing number of states, you've seen legislation attached to cannabis legalization that recognizes a principle, which is if at a state level a government's going to permit the medicinal or recreational use of cannabis, an individual shouldn't be discriminated against for that use. And I use quote marks when I said discriminated because A lot of times those laws are very general in their statement, and it's not specific to employment. But certainly those laws oftentimes now, particularly in the Midwest and the Northeast, as those are coming online, do address employment specifically and say something like, if you're an employer and you have an individual that tests positive for cannabis while they're working, or you learn that they're using cannabis off duty while they are working, can you then enforce a traditional zero tolerance, no exceptions drug testing policy and exclude that worker? The answer under state law in many of those states is you can't. And you're only going to be able to take action when the marijuana finds its way into your workplace or the individual shows up to work under the influence. So keep those laws in mind as well. So let's take a look at that next slide. This is really getting away from the direct relationship between an employee and the employer, and trying to figure out how you deal with someone who's using cannabis for medicinal or recreational purposes, and what happens when third parties get involved around a workers' comp claim or unemployment insurance claims. This is, not to repeat myself, but this is another area where the law is developing quite a bit. Many times when states have launched their legislative initiatives to determine whether or not cannabis will be legal, they've put pretty bright lines around insurance and said nothing about this law impacts insurance in a very broad sense. Other states have not done that. Some states have said we are specifically stating that health insurance carriers, including workers' comp carriers, do not have to cover cannabis. Some have said that they need to. And in other states, most noteworthy as of late, New Jersey just a couple of weeks ago had a court decision where a court said a health insurer, a workers' comp insurer, in that state had to reimburse cannabis. A similar decision took place in New Mexico. So there are cases where that's happening. So at the end of the day, where does this all leave you? Well, to be a lawyer and say it again, it's sort of going to depend on where you are located and the laws in your states and your municipalities. But there could be a situation where you have an individual who gets hurt at work, goes off for a workers' comp claim, and then seeks reimbursement for medical cannabis to treat their injury. And now you as the employer may or may not find out that you have an employee who's going to be returning to work who's used medicinal cannabis off duty. And it creates a bit of a hornet's nest for you as an employer, because now you have this knowledge that you may or may not want or need to act upon. I will say that in the states where reimbursement's been ordered or required, generally speaking, those same states will take a view that an employer should be accommodating use for medicinal reasons, or expressly say employers can't discriminate against an individual for off-duty use. So in those situations where you're aware that Bill Smith or Jane Doe is using medical marijuana to treat pain for a back injury, and when they come back 6 or 8 months later after their comp claim is resolved, you're not going to be able to take action against them anyways, even though they'll test positive for marijuana if they're tested. The other question that I get quite a bit here is, well, Dean, if I can't test on the front end when people are coming in, or I needed to soften my policies there, but I have somebody that has a workplace injury, can I engage in a drug test at that point to determine whether or not an individual was under the influence of drugs or alcohol that might have caused that injury? Most of the time, I will tell you, the law has not changed, and if you have a reasonable suspicion and a good faith basis for testing an individual, smell or slurred speech or erratic behavior, the law is still going to support you to test that individual. The reason that I'm losing more and more hair every day in a tough situation for employers is, if you have an individual that is using marijuana legally off duty, and you're as an employer in a state where you can't discriminate or exclude that individual for their off-duty use, but they come to work and they're sober, and they get into an accident and they get drug tested and they test positive for cannabis because they didn't smoke during their shift or right before it, but a day or two earlier, how do you test for the impairment in that moment that they fell over, crashed a vehicle into another vehicle, or otherwise hurt themselves? And I hate to tell you, but I don't have any really good answers for you as I sit here. There are technologies that are being developed to bring testing for marijuana impairment closer to where it is with alcohol impairment. But the drug works, it's a fat soluble drug, and it gets into your system and sort of sits there, unlike alcohol, which runs through your blood, titrates pretty quickly, and then is out of your system. So when marijuana is in your system, it's sort of there, and it sits there for quite a bit before it tapers off. So the presence of it doesn't equate to impairment, where alcohol, if you have alcohol in your blood, it directly correlates. So it's a very difficult thing to do. I would say if you have a claim or you do have a belief that there's impairment and you want to test, you probably can do that. You definitely want to get with your broker, your labor and employment counsel the minute that things are happening, so you can confirm that you can do that, and then at least provide that information to the process. So if somebody wants to push back on a workers' comp claim because of impairment, at least there is the record keeping around the observations of the impairment and the positive test to go with it. And then last but not least on that slide, we also had a comment about unemployment, the slide before that, on unemployment claims. Many times unemployment states will not reimburse for medical marijuana use to treat a disability under a state program. But there again, we're watching for the law to change and expect that it will fairly quickly as more and more states take a position that workers' comp carriers need to be reimbursing this, and workers' comp courts are saying this is something that's a reimbursable expense for certain disabilities. So let's move to the next slide. Rethinking your approach, and we have some questions here. One thing I forgot to mention, if you're watching this and you have questions that you want to shoot over to us today, you can email losscontrol@insuranceboard.org, and they'll bring those over to me, and we can answer them live as we're streaming this. So going to that last slide and going into some of the different questions that I'm seeing some of you have even before I walked in here today. Do you need to test, or do you really want to test? Well, as you probably could ascertain from my earlier comments, you may be in a state where you can't test. It's limited, but there are those circumstances. If you're in a state where it's not prohibited, really my thought to you would be, I would look at your drug testing and drug use policies sort of holistically and determine whether or not you feel you're in a situation where you need to try to enforce as much as possible what would look akin to a zero tolerance drug testing policy. If you're trying to move in that direction or stay in that sort of a space, then drug testing on the front end, if permitted, would be consistent with that. If you are not taking that position and you're not going to be concerned with employees' drug use off duty once they're employed, you may not want to subject yourself to the potential privacy claims and some of the thorny issues that come up with drug testing on the front end. If you are going to be doing drug testing, you need to make sure that your drug testing policies and protocols are reviewed with the council in the state in which you're operating. Some states allow pre-employment drug screening. Some allow suspicionless random drug testing. Others allow drug testing upon suspicion. Each state has its different formulas, and those are all developed around privacy laws that are specific to those states. And I got a lot of questions about, hey, do you have a one-size-fits-all policy on this? I wish I could give it to you guys, distribute it to you through the insurance board, and everybody would have one. The fact of the matter is there is no one-size-fits-all policy. You really need to look at where you're doing business and make a decision about what makes sense for you guys. The next question on that slide is, are there state laws or decisions impacting your drug policies that you have not considered? So traditionally, in this space of employment law, when we're talking about drug testing, when we're talking about drugs in the workplace, employers reacted to the Drug-Free Workplace Act, and whether they were federal contractors or not, they sort of adopted zero-tolerance drug testing practices, and those continue to be the norm and sit in a lot of handbooks throughout the country without folks giving them much thought. Having gone through a good chunk of the law today, it should be readily apparent to all of you that you need to be looking at the laws in your state and deciding whether or not those need to be amended, simply because the law requires it, but also if the realities of your job are that, or the workforce, or that you're having difficulty filling certain positions without screening people out, you may need to adjust those. I've had talks in front of very large employers, big box retailers, manufacturing plants, folks that are using a lot of employees with a fair amount of turnover, and a lot of the HR professionals and in-house lawyers in those facilities are struggling with how do we fill all the jobs that we need while we screen out cannabis use, because it's become so prevalent. And those employers have said, we're going to pull back on certain positions and stick to being stringent on certain others. And so these are sort of the questions that you need to ask. I will tell you that in most states where the law says thou shalt not discriminate against employees for off-duty drug use, there tend to be exceptions for employers that have individuals working in safety-sensitive positions, employees that handle firearms, not that that maybe applies to anybody in this presentation. And I know we have a lot of employers in this presentation today that have employees around children, around daycares, around nurseries, that sort of stuff. If there are bona fide occupational qualifications that you as an employer say, for people in these types of positions, we don't think it's safe to have individuals being able to consume cannabis, I would raise those issues with your counsel as you're talking about how you're going to form your policies. Because, as I said, a lot of those laws that are coming on the books recognize those concerns for employers and will allow you to take a more nuanced approach to saying, if you are in these sort of categories, it's zero tolerance. Everybody else, maybe we won't test, or maybe it won't be a zero tolerance policy, but you still can't come into work under the influence or possess cannabis or other drugs while you're at work. So some thoughts there. I think there's one more. Are you prepared to respond to positive testing, employee requests to use medical cannabis, or abuse? So again, we've walked through the law here. We've sort of seen the change state to state, and hopefully by now you have a little bit of a glimpse into the fact that you may be sitting in a state where employees have a right to use off-duty. You as an employer have an obligation to engage in the interactive process with an individual who's using cannabis for medicinal purposes. Those sort of thoughts should be in your mind and really need to be informing your approach when you come across an employee that wants to use cannabis in the workplace. Even though I'm in a state like California that's very, very liberal when it comes to cannabis legalization, we have no state's employee rights for off-duty use. Now there's bills pending, and there's bills pending all across the country that are going to change how this dynamic works for some of you. But you have to be looking at those and deciding how you're going to respond to those employee requests. So I think we are pretty close to the end of the slides. Let me just see. Yes, there's our will work for weed slide. So with the time that we have left, why don't we walk through some of the questions that we've got and see if I can't give some free legal advice, even though it pains lawyers to do that. The first question that we got before the presentation was, do we know if health insurance will cover cannabis? As I mentioned, most of the states that have come online and have added cannabis legalization to their books have done one of three things, or all of them have done one of three things. But some have said cannabis legalization has absolutely no impact on insurance, whether that's health insurance, workers' comp insurance, anything that's touched on the insurance code under state law, totally untouched. Others have said, and this is a very small few, have said, we think that cannabis legalization means reimbursements should be permitted. And a whole bunch of them have said nothing. So to answer your question, insurance is typically a monster of state law. You really have to look at the state where you're located and determine what your state law would require, and then also look at what your carriers are willing to do. There's an increasing number of workers' comp carriers that have become sophisticated in this. If they've got employers that want to provide reimbursements or coverage for this sort of stuff, they can do that. And if they have employers that don't want to do that, and they're in a state that they're permitted to say no, they're becoming more sophisticated on how to say no and push back. So that's sort of how that issue washes out. Any advice for employers in states that have legalized recreational marijuana? I've seen drug policies that run the gamut. I've written drug testing policies for cannabis operators and what I might call sort of artistic creative employers that despite my urgings and sort of cautionary tales have said we're going to have basically no policy. They permit use during work hours. There's no drug testing, you name it. And I've done policies for security firms or manufacturing production facilities where, because of the fear of what might happen, they take a very serious zero tolerance approach. When you have employees that are going to have access to recreational cannabis, the numbers don't lie. You're going to have more and more employees accessing cannabis and using cannabis off duty, and you're going to have to make a decision for your organization about whether you care about that, and if you care about that, whether you're going to be able to fill all the seats in your facility to fill the need of your business. And you're going to have to figure out where you land on all of that before you go to put pen to paper and start writing some of your policies. Another sort of interesting wrinkle that comes up here, particularly in the context of religious organizations and institutions, is I don't think most of the organizations that the insurance board does business with have taken either a religious, we're going to use cannabis for religious use stance, or as a matter of our religious theology, we bar the use of cannabis. But if the use of cannabis is either permitted or not permitted based upon a religious belief, there's a whole body of law that says the employer, the religious institution, can effectively discriminate against an individual based on religion. So if you had, for example, an applicant who was atheist try to apply to become a front office worker for a Christian faith organization, and that Christian organization says, well, we only want people that have Christian faith working for us, courts have recognized that there's a bona fide occupational qualification that religious institution is in the business and they operate for the purpose of that religious belief, and they'll be able to discriminate against an individual who doesn't share that belief. Well, similarly, if you as a religious institution have an official stance on cannabis, either permitting its use for religious reasons or excluding it, I have not seen the case yet, but it would stand to reason that if the institution's making employment decisions based on that religious belief, that courts would see that as a bona fide occupational qualification as well. So if there are those of you in the crowd that have some of that going on, that's definitely something that you can and should be factoring into how you formulate your policies with your workers. There was a question early on about how do we rewrite child protection policies to include this information. as I mentioned, I would go back to going to the state law where you are operating and seeing what the law requires of you in the first place. If the law is silent and you're in a state that doesn't have any protections, you're going to be able to do a lot. You're going to have a lot of leeway to say, we're not going to have any drug use for individuals that are dealing with children. If there are restrictions for you as a business on how you can, I'll keep using the word discriminate because that's the word that's used in statutes, but discriminate against individuals for their off-duty use, look for the exceptions and see whether or not they build in their safety-sensitive positions or an exception that would capture individuals that are working around children. Oftentimes you'll find them there. And if not, I would work with your Labor and Employment Council to see whether or not, based on all of the factors that are going on in your local municipality or your state, if you can make a really good case for bona fide occupational qualification to really sort of stand on a hill and say, we feel it's important enough that we're going to have a policy that says we're not going to have employees using cannabis in these particular positions. There was a question that just came in that said, short of hiring legal counsel, how might I find out what Ohio's laws are or another state's laws are? I will tell you that for whatever you feel about legalized cannabis, the amount of disclosure and information that's out there surrounding these programs is reassuring from a public and a lawyer standpoint. If you were to ask me, what are the packaging requirements for food, or what are the SEC requirements for trading stocks and securities, you got to search pretty far and wide and go deep into a lot of different books, and a lot of the states' websites are not very helpful. When you want to find out what the laws are relating to medical and recreational marijuana in your states, if you go on a computer and you Google legalized cannabis in Ohio or legalized cannabis in California, the state and municipal locations are really, really good about educating the public about what the laws are, what the requirements are, and what you can or can't get away with. So if you don't want to hire legal counsel and you do want to do some preliminary research first, I would say go to your state's, I'll call it the Bureau of Cannabis Control. They all have a little bit of a different name, but they all have a state specified organization that's overseeing cannabis, regulated cannabis in the state. They'll have access to all the rules and regulations there. And then if you're in a state that has a two-tiered system, meaning you have to have a local license as well as a state license to operate, look at those municipalities, because a lot of times in those cities they'll have municipal codes that dictate sort of what the operators can or can't do, what use is permitted, and some of the strictures around that as well. At present, I'm not aware of insurance coverage for medical marijuana. If so, this would increase usage, and do you anticipate this in the near future? Well, I will tell you that the insurance markets around cannabis are expanding quite a bit. So if you go into a state that has commercial cannabis, a lot of the same insurance carriers that are underwriting and providing you coverage for your general liability, your employment practices liability, that same insurance, they're not only insuring you, but they're also insuring cannabis employers. And as I mentioned a little bit ago, workers' comp carriers are becoming a lot more sophisticated in this area, and a fair number of them are learning how to deal with reimbursements. Traditional health insurance has been slow to come around. I'm not aware, there may be, but I'm not aware of a specific health insurance program that an individual can purchase that reimburses them for cannabis, but I would imagine that's probably something that's not too far off. So that's sort of where that exists. As an employer, I would be more focused on your policies and procedures for use and screening in the workplace, and if individuals make claims, work with your carrier to see how they'll respond to those, and lean on them and their resources, working with your broker or outside counsel where you feel necessary to figure out what you can or should be doing to participate in those third-party claims. I sort of stole my own thunder on this question, but there were 4 or 5 of them asking, we're thinking about writing a policy around this conversation. Do you have a sample that we can use? Or do you have a sample policy for a handbook? Do you have a sample drug testing policy? Again, as I mentioned before, these have to be state specific, and as you can sort of tell now after having talked about this for maybe 45 minutes or so, if you're in a place where you're not going to take a zero tolerance approach to cannabis in the workplace, it starts to become a discussion not only about where you geographically are located, but also what your employees are doing. If your employees are driving vehicles, if your employees are interacting with the public, if your employees are interacting with children, if your employees are interacting with individuals who have serious health conditions, terminal patients, nursing care home, palliative care home patients, the policy needs to become more nuanced. So I guess I would say you can reach out to the folks at Insurance Board to see what resources they would have, but you can also reach out to me and I can help share with you what we have already done for clients. And for those of you that have really complex issues, we can help guide you through those on a state-by-state basis. I got a question here. We're in a state where recreational marijuana is legal. Are there differences in how we address that use versus medicinal use? The short answer is yes, but I hope at this point you've got at least enough in your minds to be dangerous about responding to these issues to understand if an individual is coming forward and they're asking to use cannabis for medicinal purposes, or they're asking for an exception to be made for your policies because of medicinal use, that triggers things like disability and whether or not an accommodation needs to be made. Regardless of whether it's medicinal or recreational, if an individual comes forward or they test positive for cannabis, you have to also be asking whether there's a state's right to use statute or decision on the books that would limit your ability to, as the statutes often say, discriminate against those workers. So there are nuances here. Medicinal cannabis probably has more protections than recreational cannabis, but it's not one or the other. There will be situations for some of you in some states where, whether it's for recreational or medicinal use, you won't be able to exclude an individual from being employed because of their off-duty use. And then finally, there's a question here around SOPs for churches and the use of cannabis, and whether or not church policies can trump state or municipal rules. There, I harken back to some of my earlier comments about there might be situations where a church has an established, an announced position on cannabis use for religious practices or reasons. In those cases, there's a chance that it would trump a state's law or provide an exception to a state's law surrounding employees' use of cannabis. But outside of that, what I would say is, by and large, my view is that the state and municipal rules are going to trump what your policy says. Just because you have it on paper and you've had it for a long time and you'd like it to be one way, doesn't necessarily mean that your state's going to permit it. So you do need to check those in the absence of an established religious belief or a religious theology around cannabis. You really need to look at what's going on in your state or your municipality to determine whether or not you can have a zero tolerance policy or exclude workers from using cannabis. So with that, we're drawing up to a close. Do we have any other questions? We don't have any other questions at the moment. Again, if you have questions that we've not addressed and you've not been able to float them as of yet, I'd invite you to reach out to the email at the bottom of the screen, lostcontrol@insuranceboard.org. I'll invite Lisa and her folks to reach out to me offline, and we can try to answer those on an ad hoc basis. If you have questions for me directly and you want to reach out to me, we've got some information up there on the screen as well. My email is dean.rocco at wilsonelser.com. And if you flash the last slide in the slideshow, there's a phone number and an email address that folks can use to get a hold of me. With that being said, thank you for having me. I appreciate the time. I appreciate the Insurance Board inviting me to come speak to all of you about this topic. It's fast emerging. It changes all the time. I will tell you there are laws on the books in 6 or 7 states right now that will take them from a state that has no employee protections to one that provides very onerous employee protections. So keep an eye on these things and break yourself of that mold of sort of relying on the traditional zero tolerance drug testing policy, and really in the days and weeks to come, have a discussion within your organization about whether what you're doing works and whether or not it fits the laws within your jurisdiction. Thank you.